going to share my screen. All right, take it away, Steph.
Good morning, everybody. So Jen and I were talking, and we felt like this was an important class to discuss because it just seems like life events are really what's driving our market right now. A lot of the people that are selling because of these situations that we're going to talk about today. And I don't know about you, but I feel like sometimes it can be emotionally exhausting to deal with these types of transactions in bulk. We're dealing with people that have lost a loved one, their marriage is falling apart and they're having to sell the house that they didn't intend to sell that was going to be their forever home, or a family member that's gotten older and needs to get moved into a care facility. So for me, it's been draining a little bit these last few months of this year, just dealing with these types of transactions. But I felt like it would be helpful for us to all kind of get on the same page so we're aware of what's going to be needed on the title side of things when you enter into this type of a transaction. And kind of before I get started, I wanted to just say that there is a difference between what's legally required for some of these situations and what the title company is going to ask for. And that's because we are an insurance company. We're going to assess risks of every situation and on a case-by-case basis. Not every situation is exactly the same. Some of them, they're going to have different requirements just based on the scenarios that come up for that. So I just wanted to say that while sometimes we get approached with things, well, legally this isn't required, but for us to insure it and our comfort level, these are the things that we're going to need and ask for. And I also wanted to just say, we'll go through the slides. Do ask Jen for copies of those. They have a lot of great information. I'm going to try to just tell stories as we go along because, believe it or not, I think I've had an escrow with every single one of these situations come up before. So I just want to kind of share what experiences we've had with that. Okay, Jen. First thing first, if you do have a transaction where you know one of these situations is relevant, communicate that to your escrow officer from the get-go. Oftentimes we'll say, tell us about it when you're taking the listing so that we can look at the documentation ahead of time, review it, see what's needed. If it's something that is going to require extra time and attention, then we can deal with that ahead of time.
So the last payment.
Okay, so starting with death, when the D is for death. Sometimes it can be straightforward. If the owners are in title as joint tenants, husband and wife is joint tenants, unmarried man, unmarried woman is joint tenants, and one of the people on title has passed away, that's pretty straightforward. We're going to need the original certified death certificate. We're going to record an affidavit of death of joint tenants, move forward. There's no probate needed for that. Second one is community property with right of survivorship. This one's also straightforward. What I have had happen on this one is the document for that affidavit of death. The person is signing saying that the decedent has passed and at least 40 days have lapsed. Well, I went into contract on an escrow once and the husband died, 3 days before I think the contract was signed. And it was a 30-day escrow. So, but for that file, we had to get an extension because we couldn't record and close on it until those 40 days had expired. That was a first for me. That doesn't usually happen, but some of these things do have time frames. So that's something to consider. The revocable transfer on death deed. A lot of people have been using these to try to do estate planning where they don't want to go set up a trust and spend the money on that. I would just say that with these, it's not always so straightforward because the title company is going to require a lot of documentation to pass on those without a probate. When the person dies and there's a transfer on death deed, and for those of you that don't know, that's a deed that says, when I die, I want my property to go to these beneficiaries. They record it on the property before they die so that it's there and it's memorialized in the title chain. When the person dies, the beneficiaries have to go in and record an affidavit of death for the transfer on death deed. And a certain amount of time has to pass before you can then proceed with selling the property. And there's going to be a big long list of documents that the title underwriter is going to ask for that. They're going to want to know, did the person have other children that weren't listed as beneficiaries on that? There's affidavits that need to be signed. It's not quite so straightforward, and there is extra paperwork that's involved in it. So I just wanted to say that. There's also no probate for a trust. So we like trust because they tell us what to do. Where there's a will, there's a better way. This has happened a lot. It's pretty sad. When somebody brings me an escrow, the person that's on title is not the person that signed the contract. There's only one person on title, or there was two and they're both dead. And the agent will, or the seller will tell me, well, this property was willed to me, so I can sell it. And it doesn't quite work like that. So there's two types of situations that'll come up. One is if there was a will or there was not. Either way, those are both going to need to go to probate. Just because there's a will doesn't mean that the property is automatically going to pass to the people that are listed in there. And that's happened just so many times. It's unfortunate because you're entering into the contract with a buyer expecting it's going to close in a certain time frame, and then we have to be the bearers of bad news to say, no, actually you need to go do a probate for that. And so the purpose of a probate is to search to make sure that there's that all the heirs potentially that have an interest in that asset have been notified. And it's a process, it's a lengthy one. But it is possible to close an escrow before the probate itself is actually completed. And that's when the court assigns an administrator to the estate that's going to sign all of the documents for the sale. We close the escrow. The proceeds then get deposited into a bank account for the estate. And then the administrator just has to wait until the probate's concluded to then pay those funds to the heirs. It can slow down if somebody objects to the probate. So Jen's got some slides in there for the timeline of that that you can look at later. What I will say is that there's a lot of weird things that can pop up on a probate or properties that people thought were going to avoid probate. I had one recently where the parents had put the home into all of their kids' names, but the deed, instead of saying as joint tenants, it said as tenants in common. And tenants in common is not the same thing as joint tenants. It separates the interest out individually for each owner. And so one of the brothers that had been put on there had passed away. The siblings thought it was joint tenancy. And so they tried to just transfer, the deed through the years. And we get to the escrow and it's like, no, his interest was not dealt with, and a probate had to be done years later. And so that delayed that file for a while before they were able to move forward and close it. Sometimes the court will do an order determining succession, where the property will then pass through to the heirs, and that document gets recorded, and then those heirs will be the sellers that act in the transaction, not necessarily the estate itself. Who gets the money in the probate sale? We don't disperse the funds to the heirs unless the property has had that order determining succession where it's deeded directly to them. If it's to the estate, then we're going to make that check at closing payable to the estate. Moving on to trusts. Trusts are going to tell us what happens when there's a death of a trustee. One thing that I find is that there's
what's going on, Jeff?
Properties that get put into escrow where the property's already passed through the trust transfer deeds. Mom and dad passed away. One of the siblings was the successor trustee. They transferred the property to themselves because they were the only beneficiary, and then they're going to sell the property individually. And then the escrow comes to us. We still have to, as a title company, go back and ask for a copy of that original trust because we're insuring against heirs. And so we have to go back and make sure that the person that signed that deed was the successor trustee, that they were listed as the only beneficiary. And I know sometimes that can feel like we're invading people's privacy a little bit because we're asking for personal documentation, but the real reason for that is to avoid a situation in the future where the buyer was contacted by somebody. I was, so-and-so's daughter. I was entitled to this property. It shouldn't have been sold. And that does happen. I mean, siblings fight over money. I don't think that's a big secret to anybody. Families fight when there's money involved. So it is important for us to get copies of those documents, review them with the title officer, and make sure that everyone that's signing is the person that needs to sign. And it's important for you as the listing agent. If you go to your listing appointment and you're meeting with, John Smith, and he says, this is my parents' house, I'm the successor trustee. Well, what if when we get into escrow and we ask for a copy of that trust, John had a sister that was also supposed to serve as the successor trustee, and she's going to need to sign those documents as well. So always important, I would say, to ask for those copies, ask for them ahead of time if you can, and send them to us before, as a pre-open. Ask us to look at it. What are we going to need on this? Who needs to sign? I've had files in the past where the property was in escrow. The dad had resigned as the trustee, and so the siblings were going to sign. Dad was getting older, didn't want to handle that paperwork anymore. He actually passed away before the escrow had closed, and just so happened to reread the trust documents. And that particular trust said that the kids would sign for the trust while the parents were still living if they had resigned. But once both parents had passed away, there was a separate person that was going to be the successor trustee that was not one of the kids. Not super common, but things like that can happen. And so we had to, stop and redo all of the paperwork to have this other person be the signer for the trust.
Steph, we do have a question. Ariel has asked, when there is a trust and people think that a power of attorney can be used, is there a clause that we look for in the trust that addresses the power of attorney?
Yes. Super great question, Ariel. Thank you. A lot of people will tell me there's a power of attorney that we want to use for this trust. We can only use the power of attorney for a trust if the trust specifically allows for it. And so that's my first question. If somebody tries to use a power of attorney where there's a trust, I say, I need to see a copy of the trust because we have to read through it. And honestly, most of the time, it doesn't allow for the use of a power of attorney. They probably have that power of attorney so that they can use it for other bank accounts or assets that were not put into the name of the trust. Sometimes it's for a health directive. I've only had maybe 1 or 2 files in 20 plus years where the trust allowed for the use of a power of attorney. And the reason for that is because the trust has already set up guidelines and parameters for who can sign if the sellers are not able to. And that's also like a security thing. We don't want to use a power of attorney for a trust if the sellers just happen to be, out of state, out of the country. It's really only going to be necessary if they are unable to perform their duties as trustees anymore. So great question. Where was I going?
That we have is it technically has to be for that specific transaction, correct?
The power of attorney?
Yes.
Yeah, so power of attorneys, we need to review them with title before we use them. They'll need to be a specific power of attorney that says that it's for use in real estate transactions. If it just speaks to financial things like bank accounts or health things, we're probably not going to be able to use that power of attorney. It needs to specifically say that it's for real estate transactions. When we close the escrow for a property that's in a trust, we're going to pay the money to the trust. Even if the trustees have passed away and the successor trustee says, oh, well, it's just me and my sister that are the beneficiaries. So can you just write the check at closing, half and half to each of us? We're not going to do that. Title is not going to get involved in distributing the trust assets to the beneficiaries for liability reasons. So we're always going to only have the proceeds paid to the trust at closing. And that's a conversation that I try to have up front, because a lot of people forget to open their bank accounts in the trust name. I don't know why, but that happens. And then we get to closing and they're like, what am I supposed to do with this check? I don't have anywhere to put it. So that's a good conversation for you to have as well, if you see that you're taking a listing, because it gives them time to do that. Anymore, you've got to make an appointment at the bank, bring the trust documents there. And in the midst of packing up a house and moving, it can be stressful for people to do those kinds of things at the last minute. So I feel like if we're all communicating the same things to them, it gives them a lot of time to plan and prepare for that. Making things more complicated when people die during escrow. I talked about that one file where somebody died, and the trust documents were changed. It makes it complicated when nobody tells us that a seller is dead. I don't know why, but we'll get a prelim, start working on it. Nobody's told us that, the seller has died or what their situation is. And I feel like it's so helpful to tell us, because I don't want to call somebody and ask, oh, is so-and-so available to sign, and oh, they passed away. It's awkward and uncomfortable, and over communication for special circumstances in escrow is highly desirable. If they die during the escrow, this has happened, you guys. Like, I had a file once where the sellers signed all their paperwork to sell a property. And then the very next morning, the husband calls and says, my wife took her own life last night. She's gone. She's dead. And I was like, okay. I went to my escrow manager and he's said, did she sign everything? And she'd signed everything, and the seller still wanted to sell and the buyer still wanted to buy. So we were able to move forward and close the escrow. When it's not going to work out like that is if you are using a power of attorney for somebody, because a power of attorney is a living document that dies when that person dies. You don't still get to use power of attorney for them after they've passed away. And that's happened before also. And that, halts the file and makes things kind of start over. If the buyer dies prior to the close of escrow, we're usually just going to cancel it and return the funds and the documents, unless there's somebody that is a surviving spouse that wants to proceed with the file. Okay, when the D is for divorce. So this is the one that when I was talking about like what's legally required and what the title company is requiring, this is kind of where it gets into it, because a lot of buyers are trying to purchase property before they have a divorce that's finalized. And I will just tell you that in the 4 scenarios that's listed on there, the 3, if you're just separated or you're legally separated or your divorce is filed but not final, in any of those situations as a buyer, the title company is still going to ask for a spousal deed to be signed by your soon-to-be ex-spouse in order for that buyer to take title as their sole and separate property. So I just had this happen on a transaction. Seller went to sell a property. The prelim comes over and it says she's entitled as a married woman. It does not say as her sole and separate property. And I'm like, well, she bought this in the 80s. Like, really? Nobody dealt with spousal interest all this time? Go back through the title chain, look at it through my title officer. No, she bought it. Never even took a loan out on it all those years. And so I called her and I asked, were you married at the time? And she was in the middle of a divorce when she bought it. For whatever reason, the spouse at that time did not sign a spousal deed. And so she took title as a married woman. And so I asked her to go get me her divorce paperwork so I could see when it was finalized and everything. You guys, she closed escrow, and 4 days later, the divorce was finalized. So she was still legally married at the time that the escrow closed. And for title purposes, we're going to make a decision that avoids us from having to go argue our position in court should somebody go and challenge heirs and things later. Well, her ex-husband had just passed away last year, so he wasn't even still around for us to go back and ask, hey, can you sign this spousal deed now? And so the underwriter for us said, in order to move forward, we were going to need to have a probate for that deceased ex-husband. So I'll say that cash buyers ask all the time, can we just close and deal with this later? Well, this is what happens if you decide to just deal with things later. A lot of times it's way more convoluted and difficult to address at that time. It is possible to, if you have somebody that, like, you don't know where your ex is, they decided to go, hit the road, van life, whatever, they're off grid. There's documents that you can file with your attorney in the court where the court can sign the spousal deed to relinquish that person's interest, but that has timeframes and appeal periods that would need to expire before you could then move forward on a transaction. So all that to say, if and when at all possible, get that spousal deed signed. For sellers, when we're dealing with the divorce situation, the biggest thing that comes up with them is dividing and splitting the proceeds at closing. And so for the title company, our position is that when people are in title as joint tenants, we're going to issue one check at closing to both of them, unless we have mutually agreed upon instructions that tell us to divide the proceeds another way. And so I like to have that conversation up front when the parties are getting divorced, because if they're not going to agree how to split the funds, then our options are limited on what we'll do. It is possible that they can decide, if they're working with attorneys, we can pay the proceeds to their attorney's trust account, and then the attorney can just hold that money until they've reached a settlement agreement or decide how the funds are going to be split. And that happens a lot when they can't decide what to agree, but we still have to have both of them agree to do that, unless there is an order that's signed by a judge that tells us to. That's the only situation where we don't have to have the two parties agree on how those funds are going to be split. And that comes up a lot. So I had a file, maybe Jen will go ahead to the case of the missing ex-spouse. So this one kind of is an interesting story because it involves like all the different scenarios. There was a trust, there was a probate, there was a spousal interest, and all these things. So a file was presented to me where we had to go back and verify that the deeds in the title chain were done correctly. So we're asking for copies of trust documents and power of attorneys that were used. And there was a deed that was recorded, signed by a power of attorney, to put a property into a trust for a seller. And I asked the question, is that person still living that the power of attorney was used for? And the answer was no. And so I said, can I see a copy of the death certificate for the file? Well, the death certificate showed that the woman had died 2 days before the power of attorney signed the deed. So that means that the power of attorney was no longer valid for that deed that transferred the property into the trust. And so we had to deal with spousal interest that remained from that not transferring. This woman had been married when she went into title, but had gotten divorced. The divorce didn't name this property because it was her sister just transferring it to her in case something happened to her. But we had to go back and find the ex-husband, and he didn't want to sign the spousal deed because he decided that he wanted to try to get some money out of the transaction. So he objected to the probate, which stopped all of that for months. And it ended up delaying the whole transaction by like 6 months because of that. And then when he finally realized that nothing was going to work out for him to get those funds, he did finally agree to sign the spousal deed and we could move forward. But it was kind of just a case of where everything that could go wrong in that transaction did. And this, what should have been a really simple transaction to close in 30 days ended up taking, like I said, 6 months. So that was a wild one. Moving on to dementia, I gotta say, like, one of the more frequent calls that I get is, seller has this property. He's kind of like early onset, can sign, has good days and bad days. It's just when you have that conversation with escrow, it's going to immediately like raise questions for us. Well, what do you mean like good days, bad days? Like it matters to us, someone's cognitive ability to sign a deed to transfer title to their home. So if you're going to come to your escrow officer and say that, hey, they have a little bit of dementia, but not much, it's just going to raise a lot of questions for us. And so basically, if there's a trust, somebody's not able to sign because of incapacity, the trust is going to tell us what's required to remove that person as a trustee. Sometimes it's one doctor's note, sometimes it's two. And we're going to need that for the file. If there is no trust and someone has a power of attorney that they've presented and it's the same situation, we're going to start with one doctor's note. Let's have one to see, what the doctor says for that. But it gets interesting when a power of attorney was just signed. Like say they just signed the power of attorney like a week before they try to go into escrow, and then we get a doctor's note that's dated kind of in the same time frame. Then the title department's going to ask, well, how are they not able to sign now, April 12th, but they could sign when they signed this power of attorney on April 5th. And we're going to have a hard time feeling comfortable with that. So a lot of times, even if there's a power of attorney that was signed and a doctor's note, if those dates are really close, the title department may still then ask for a conservatorship to be established. And I've had that happen before. In a transaction, you can think that you've got all of the documentation, but if those dates are like right lined up, then that's not really going to work out. So you're going to present a power of attorney to escrow. I think I talked about this earlier, but a general power of attorney and a specific power of attorney. So the specific power of attorney is going to say that it's specifically to use for this transaction for real estate purposes. The general power of attorney, sometimes we can use them, but they do have to say that it's for use in resident or properties to be transferred. So always a good idea if somebody tells you, my dad can't sign, I'm going to sign for him, I've got a power of attorney. Get that to escrow so they can look at it ahead of time. They can review it with the title officer. That document's going to need to get recorded with the file with the county recorder if it hasn't been already. So they're going to need to make sure that they've got the original. We don't like to use power of attorneys to complete our transactions because it's a high risk situation. So there's going to be extra requirements that need to be met for that to happen. We're going to ask, how old was it? When was it signed? Do the signature on the power of attorney match those that we can see in the title chain? Is the notary that signed it approved by the title company? There's all kinds of horror stories of family members that will have a power of attorney drafted, forge a parent's signature, get it, stamped by a notary whose notary stamp has been compromised, and they try to either liquidate assets or, with a hard money loan or selling the property. And so cases like this are why we have to ask so many questions when it comes to power of attorney. When at all possible, and we have to use them, we're going to want to communicate with the principal to make sure that they understand the transaction, that they understand the property is being sold, and that they agree to have that person sign. Obviously, in the case of someone that has dementia, we're not able to do that. So that's why we have to ask for the doctor's note. How long is the power of attorney valid? Well, it depends, and it's a case-by-case basis because they're all different. They're drawn different. Some will have an expiration date on them. When we draw a power of attorney in our escrow file to use, if a seller is getting ready to be deployed, they're in the military, or they know they're going to be out of the country for the transaction, it's not unusual for them to say, can I come sign a power of attorney with you before I leave so that I can have this person sign for me? We will do that because we have direct communication with the seller. We're preparing the document, but when we do that, it's going to be specific to that property that's being sold, and it's going to have an expiration date on it. A lot of times, if there's a really old power of attorney that's being presented to be used, somebody had it prepared for estate planning purposes just in case, then we're going to have the person that's signing as power of attorney sign an affidavit for our file that it has not been terminated or revoked. Conservatorship is going to be something that comes up if there is not a valid power of attorney in place, or like I said, if there's one that maybe was, but it was just recently signed. And so the court is going to have to decide who's going to be the person that has the conservatorship and can sign for that individual. The timeline on it varies, but we can't close the escrow until that's been established and we know who can sign for the individual. This was our awesome question earlier from Ariel, power of attorneys and trusts. Not always, but sometimes. I think that's what I had. I talk fast, sorry. Do you guys have questions? I know this comes up a lot. There's just so many right now. There's, I mean, I would have to say most of our files right now fall into one of these categories. Not all of them, but most of them.
Steph, we had one right as we were segueing from death to divorce that said, assuming nothing funky on the trust, husband and wife trustees pass away and son and daughter are the beneficiaries clearly outlined in the trust that they are to get the property. Should they transfer title to themselves prior to selling the house or financing the house?
They can. It just depends on what they're trying to do and what their attorney recommends. If they're going to be doing a loan, the lender might need it to be in their name if they're going to do a refinance. But in either one of those scenarios, they should remember to keep copies of the trust documents because you're still going to have to provide them to the title company when you go to complete one of those transactions because they're going to need to verify that information that they were the only two beneficiaries. And if it was for both of them and they agreed, they split other assets. And so they decide, well, we're going to put the house into the sister's name because brother's going to get like the investment accounts or whatever. Then we're likely going to ask for a consent form signed by the other beneficiary that, yes, they approve of that. But that's only if the attorney didn't prepare that. A lot of them are really good about preparing those kinds of documents that state how the assets were distributed and signed by both of them. And so we'd need a copy of that as well.
And then we talked a lot about the selling end on dementia, but are you also finding sometimes when people are trying to refinance a property or purchase a property, possibly not with a spouse, but with a kid or a partner, are you running into any dementia situations on that end? And is there any difference in how title will ask you to handle that?
I have had that happen where a husband and wife own the property together and the wife had memory care. She was in a memory care facility. They never took her off title. And so the husband went and refied the property, I think twice. And there was a valid power of attorney in place and we had doctor's notes. And so he signed all of the documents for them for that. So that has come up, not super often, but it has.
Okay. And not so much on the buyer's end?
Not really. I did have one recently that was the trust that was buying the property for the benefit of the mom who was the original trustee. Dad had died. So we did get a copy of his death certificate just to verify that. And the mom, we had a doctor's note to show why she wasn't signing. But yeah, so the two daughters signed the trust, signed as successor trustees of the trust. Because they were buying the house with the trust assets for mom. I think relocating her to where they were, something like that.
Okay, and we have a couple more questions. It says you mentioned earlier foreign or principals using their attorneys overseas or using a power of attorney from there. I think we just need to clarify what power of attorneys we accept. I think it's people traveling to foreign countries, not foreign power of attorneys, correct?
So we're probably, yeah. If they're in a foreign country, we're going to likely ask that they still sign the grant deed at an embassy or with the remote online notarization. We're still going to want at least that document signed by the principal, and then we can use the power of attorney to sign any other escrow documents. That's our comfort level with that. If it's somebody that came and wanted to sign with me before they left the country, then I would prepare the power of attorney and I'd probably also prepare a grant deed for them to sign too. I have done it on some files that are pre-opens, and I'll prepare an instruction for the seller that's signing the grant deed, basically where the buyer's name isn't there yet. And the instruction is that we're going to insert the buyer's name on that deed once the contract's in escrow, but we're still going to have direct communication with that seller via email, via phone while they're gone, so that they can still DocuSign the remaining documents for the file.
And then we had a question, does the POA go hand in hand with the trust? Is it a good idea to have a POA with every trust?
I think that's probably something an attorney would speak to. Most of the trusts that I've seen, when people bring their trust binders in to me to look at, the attorney will have done a trust and also a power of attorney for those situations where the assets weren't put into the trust name, or they'll have like the medical directive power of attorney signed that can be used at the hospital. So a lot of attorneys will do all of that at one time.
And then I haven't heard of this, so this is a chance for me to possibly learn something new. Brian Gearhart's asking, what about a pour over will? Have we dealt with those? That's not a term that's familiar to me.
I don't know either. It's probably something that's going to come up in the probate process, because it's not something that I've ever come across directly. Likely it's a conversation with the attorney during the probate itself. But regardless, a will is not going to transfer title to a property because it's not that type of a document. So I would imagine it's still going to require a probate. Maybe it'll just change what type of probate it is.
Well, I don't see any other questions in the chat, but we do have a little bit of time left. If anybody would like to unmute and directly ask Stephanie a question or something that's pinging through their head on this subject, you're welcome to do so at this time.
I have a question. Can you hear me?
Yeah.
Yes.
Okay. Okay, if there's an ongoing court issue of a squatter on a piece of property, there's a POA for to sell or to buy or whatever, but a judge will not let you say anything or talk to him because you're not on title. So would it be a better idea to have that person on title so they could help the situation, because the seller is not always available and they're related, obviously.
Who's going to put them on title? The person that has a power of attorney?
No, the person that owns the property.
Okay. And they're still able to sign and can put them on title?
Yes.
Okay. I mean, they can. Nothing's, stopping them from doing that. They'd need to consider, when you put somebody on title with you, that if that person has liens or judgments, then those could attach to the property and need to be dealt with.
I know that is an issue.
Yeah.
There are liens, but some of those liens can be taken off as soon as we can prove that the parties have been trying to get this squatter off for several for quite a long time. Quite a long time. So yeah, that is a concern.
And that doesn't sound fun.
So yeah, a mess. It's actually a mess, but that is kind of scary to put somebody on title when there's liens on the property too. Right. So maybe I should get some legal advice on that as well.
Yeah. Or if that person's married, then they'll have spousal interests as well.
Oh, they're not no, there's no marriage.
Yeah.
Okay. Thank you.
Yeah, you're welcome.
Okay, I have a question.
Yeah.
Okay, Cheryl.
Yeah, hey, I'm wondering, so if the property there's a value limit that it has to go to probate only if it's over, I don't remember, 80,000 or something, correct?
I don't remember the exact dollar amount, but I know that there's the small ones and then the large estate ones.
Yeah, so if it's under that dollar amount and it's not in a trust, you guys get paperwork, someone's deceased or whatever, you guys get that paperwork. Do you need any, will you still say it needs to go through a probate? Even if it doesn't meet that threshold?
Yeah, because there still is a type of a probate that it's gonna have. It just might not take as long as the other kind.
Okay, good to know.
I have a question. So when you have a revocable trust, does that avoid estate taxes?
I am not a tax expert, so I can't speak to that.
Okay.
Sorry.
That's definitely a question for a CPA.
We do have another question. How do we find out if the notary is approved by our company that notarized an updated power of attorney? The trust was originally done in 2005, updated in 2023.
Send a copy of it to us and we can check. We have like a database of all of our company approved notaries that we can look at. And then we can also look the notaries up with the Secretary of State to make sure that they still had a valid commission at that time.
Great.
Stephanie, one of the things you didn't touch on the power of attorney and stuff is when people were out of the country, agents letting us know, because we don't always know. People leave.
Yeah, if you know that your client's going to be traveling out of the country, let us know so that we can plan ahead of time to possibly have them sign a power of attorney or just get them in to sign the notarized portion of their documents right away. And then they can DocuSign everything else.
Sure, Sarah, she says, we usually don't know either.
Lenders and escrow always find things out last.
All right. Well, I think that is all the questions and everything that we have. Thank you. Oh, wait, we have one more. If they're signing out of the country, how would that work? Would it be at an embassy? So Steph, if you want to just type or talk about that super briefly.
Yeah, so we can have them sign at an embassy, or if all of the requirements are needed to do a RON notarization, we can do that. And that's the remote online notarization. That's a new thing that is available kind of just on a case-by-case basis. They have to have valid ID. They have to have a way to do a video call with the notary, strong enough internet connection, you know, so somebody who's like out in the outback of Australia, that might not work out for them. But there is a list and it's only going to be through our approved platform to do that. But that is a new thing that we can do on a case-by-case basis. But otherwise, yeah, we'd have them go sign the document at the embassy. It gets sent back to us. And usually, like I said, we're only going to have them sign like the grant deed or something else that needs to get recorded, and everything else can get DocuSigned.
Great. All right. Well, thank you again for taking time, everyone, from a busy Friday to join us. This has been recorded and will be posted to our YouTube channel, which is Chicagotitlefresno on YouTube. We post all of our classes there so that you can either share them or review them. And of course, if you need anything else, don't hesitate to reach out to me, your sales team, or your escrow officer. Have a great day.
Thank you.
Bye, everybody.
Bye. Have a good
Hey,
weekend.
everybody. Thanks for joining us today.
Thank you, you guys.
See you tomorrow, Kim.
Ooh, shout out to Brad, who always goes downtown to get my documents I need on these dead people files.